Perfect, perfect. Welcome back, everybody. Thank you so much for tuning in to the Unscripted Support Podcast. Today we have Christian Smith, the founder of Smith Will and Trust. He's also part of the directory as a member. But today we're going to talk about his background, everything he's done, and obviously the solutions and everything he provides. So, Christian, welcome. I will not provide your introduction. If you can do it yourself, I would appreciate it.
Yeah, that sounds good. I appreciate you having me on board, and I'm looking forward to providing some value, answering some questions, and helping to distill down some of the pretty complex legal framework that we have in place here in Florida. I'm happy to answer questions, and my contact info is going to be available in the directory. So thanks for having me on board, and I look forward to chatting with you.
Of course. No, no, the pleasure is ours. So, share with us your background, how everything started. Obviously, you're in the legal planning side, but how Christian started in all this. What inspired you, basically?
Yeah, absolutely. So, it started back when I was in law school. I was my grandpa's caretaker, and unfortunately, he passed on my watch. One day I was coming back from class and found him and looked everywhere, when the coming weeks, when it comes to administration of an estate, we have to basically reach out as soon as somebody passes away in order to administer the estate.
Yeah.
And I was shadowing an attorney at the time. He was a probate attorney, Mr. Iser in Germantown, Ohio. So if he's watching this podcast, that would be cool. Now that I'm an attorney and no longer his student and pupil. Um, anyway, I was shadowing him, and unfortunately, when my grandpa passed, I didn't really have a chance to mourn because the second that we had to launch a probate proceeding, the family drama started. He had no documentation. We looked throughout his house, safety deposit box. He'd never executed a simple will or a trust. He was a steel worker, so he didn't really worry about setting up a trust fund for his kids or grandkids. He just was hoping for the best and figured since he worked hard, it would automatically take care of itself. And unfortunately, that wasn't the case. That court battle took over a year. My mom and my aunt to this day still aren't talking. Cost us over 50 grand. I mean, it was really, really expensive. So instead of, smoothly being able to mourn my grandpa's passing, and really he was my father growing up, we had to fight in court and spend a lot of money in order to administer his estate. So that's
Wow.
part of the reason why I do what I do is after shadowing that attorney in law school, I figured, hey, I could help people avoid what I went through. And that's what
Yeah.
I did. I've helped thousands of families in the state of Florida setting up trust funds to avoid probate,
Mhm.
powers of attorney to avoid guardianship, as well
Yeah.
as special needs trust to maintain benefits and the integrity of the family unit.
That's huge, and I think that that's often not talked about conversation in the family household, and for what I understand, it's a process that it's fairly easy to to go through the trust process and create one versus just going to the court, uh, having everybody invoice you for every minute. I completely understand why you got into this. So now we're talking about in this case, and we want to use this use case for families, special needs. So I've seen a lot of different scenarios. Like for example, in special needs planning, there's you can basically it's a tailored for what I understand. It's a tailored approach. So I've seen families that have created a trust and they use a provision of a special needs trust, for example, or they use a a standalone special needs trust. There's guardianship, hybrid guardianship, power of attorneys. There's a lot of ways to be able to help a family, and what I like is it's tailored, right? It's not just a one size fits all. So now, what I wanted to ask you is around what would be the definition of a special needs trust for those families who are listening, and why it's so important for families that with special needs to have it in place.
Yeah, good question. And Big picture, there are a few types of special needs trusts. The primary version of special needs trust that I prepare, it's a third party
Mm,
special needs trust, which basically means, as mom and dad or grandma, grandpa, you're taking care of a child or grandchild who is on benefits, who's has special needs that need to be taken care of. And with a third party special needs trust, essentially you're putting your money into that trust fund and
mm,
ensuring that the beneficiary who has the special needs is not receiving a lump sum outright in their name. They can be taken care of using that money, and that's the whole point of it.
mhm,
But dumping that money in their lap is what can and will remove them from benefits in most cases. Um, so we want to ensure that it supplants or supplements the benefits and doesn't supplant the benefit. Essentially, the big picture of what a special needs trust does is
yeah.
it supplements the benefits that government benefits have already been providing, and then it doesn't replace what those are providing. That can actually result in violation of the Medicaid rules and special needs benefits rules, and
Yeah.
that the benefits could be lost
Mm,
if the trust isn't structured properly, or let's say you have named that child or grandchild directly on an account.
mm,
Payable on death designation or transfer on death designation goes into their pocket. It's in an account tethered to their social. So what a special needs trust does is allows for those funds to be used for their care,
mhm.
but it doesn't knock them off benefits. So it maintains quality of life for that person that you care about.
Yeah. So that's one of the type of a special needs trust. So that's and then there's you mentioned two more.
Yeah, yeah. So there's basically self-settled special needs trust. So those are a little different. The third party special needs trust that I just mentioned is what people use in revocable trusts, or
Hmm.
they'll have a standalone separate trust just for that special needs beneficiary. That's for money that's not earned by the disabled beneficiary. The other trust that I was referencing that is going to be self-settled. That means, let's say, for example, you're watching this and you had a really bad accident. Let's say you're on benefits and you receive a settlement for your personal injury suit. Well, you obviously don't want to have to spend all of that down on your medical care. So
Hmm.
that self-settled special needs trust allows you to manage your own fund, while also not spending all of that money down if it were just put in your name directly.
Yeah.
There are limitations on that. Basically, in the state of Florida, if you're 65 or older, you can't do a special needs trust that's self-settled. You have
Mm,
to do a pooled trust, which is the other type, where you have to have someone else other than yourself serve. So if you're injured and you're elderly, that's where a pooled trust would come into play. If you're younger and you've been injured, a self-settled special needs trust is standard. And for most of our viewers, a third party special needs trust that is embedded in a revocable trust that
mm,
springs out for that special needs beneficiary, or a
mhm.
separate third party special needs trust is what would be constructed to maintain the benefits.
Now, talking about the special needs trust, and we need also to talk about the funding mechanism, right? Because you can have a trust, but if it's not funded, well, there it's going to be complicated. So in that case, I understand that there's several funding mechanisms, but can you share, if possible, some mechanisms that can be used for the trust?
Yeah, absolutely. So, and I always like to say none of this is automatic.
Mm-hmm.
A trust is just a fancy stack of paper until it's been funded. It
Mm-hmm.
looks great. It has a lot of fancy words on it.
Yeah.
Problem is that's all it is until it's been adequately funded. The way that that's done is real estate is retitled in that special needs trust name through what's called a deed.
Mm-hmm.
Use a deed to trust called a quit claim or a warranty deed. We got to have that signed in front of two witnesses in a notary. It's stamped and then it's sealed and sent to the court for recording. So that is one mechanism of funding. Real estate requires a deed to trust. That's the instrument. If there's any corporate assets, let's say you're mom and dad, you're watching and you're running a company. And you want to make sure your
Yeah.
child has benefits. Well, if the company has not been assigned, meaning the shares have not been issued in the name of that special needs trust, then when that goes through probate, if your child is the natural heir, it's going to knock them off of benefits because the proceeds of that corporation, the operating account, any of the assets, rental properties, and so on will be sold and distributed in that beneficiary's name directly. Then, after they spin down the inheritance, then they can have benefits in place. So those are the two funding mechanisms for corporate and real estate assets. Financial accounts, we use what's called designation forms. So if you have a checking, savings, or brokerage account, all you need to do is list the trust as beneficiary on that account. When you pass away, that account will be retitled in the name of your trust, and the special needs provisions within that trust will prevent the beneficiary from receiving that account in full. Instead, the trustee will hold it, not the beneficiary.
Mm, mm. 100%. 100%. So we have real estate. There's a bunch of them. So that's, it's good for families to understand that. So they understand that it's not only one type of mechanism. Even life insurance can be used for that. Yeah, that's really good. Thank you for that.
Yeah, of course. And to your point, life insurance is super important. I can't tell you how many times I've talked to clients who, after their parents have passed away, and all the debts have been paid, there really isn't that much left over, even after decades of hard work. A
Yeah.
life insurance policy is a guarantee, right? That money is going to pay tax-free outside of probate to the beneficiary. It's
Mm,
really important in that it's like other financial accounts like checking, savings, and brokerage accounts, and that life insurance policy should not name the beneficiary directly. It
mm,
should name the trust fund,
yeah.
so that way it is still a tax-free inheritance, but it's not going to be subject to spend down requirements
Mm,
before that beneficiary's benefits kick in.
yeah, 100%. Now, let's talk about misconceptions around special needs trust. Do you have a couple, maybe three, one, two misconceptions? Any misconception that you might see when attending these type of families?
Yeah, number one misconception, I think I've said it a couple of times so far, is that it's automatic, that because I have a will in place, that I'm going to avoid probate.
Mm,
Or number two, that because I have a life insurance policy in place, it's
mm,
not going to be subject to spend down requirements in order for benefits to be issued or maintained. Those are the two big ones
yeah,
where I'll have clients who think that they're doing the right thing by going to their local, general practitioner who does a little bit of this, a little bit of that, some criminal defense, some personal injury. They draft up a will naming their child as beneficiary. It is not automatic in terms of the special needs structure.
yeah,
That requires, careful crafting of the special needs provisions,
yeah,
and the beneficiary needs to be indicated as a special needs beneficiary. So it's not the protection is not automatically extended to a beneficiary just because you had your will done. So that's the number one issue. Number two is for policies that people pay, premiums for, and accounts that they've worked hard to fund. Naming the beneficiary directly is not going to impart the special needs provisions of the trust. So again, even if you've paid an estate attorney who does elder law to set up a trust fund with the proper special needs provisions, actually making it work is not automatic. You have to name the trust as beneficiary. Otherwise, that beneficiary is going to lose their benefits or be unable to apply for them in the first place.
yeah, 100%. Now, so we walk through the definition of the trust, why it's important, funding mechanisms that can be used, misconceptions. Now, something that I believe it's important is how does it work? We already have it. Let's say it's already set up. We already have it's already funded. What's next? What if that person would pass away? Also, we can also talk about dabble in a little bit about the roles, right? There's the trustee, the grantor, and then So maybe we can talk about that.
Sure. Yeah, roles are important. So big picture, and I always like to say that a trust is only as good as the trustee because whoever you name is responsible for carrying out your wishes. So if
Hmm.
we set up a trust and mom and dad are watching, or just mom or just dad, you are the grantor of the trust fund. So if you're putting your money into a trust, you are the grantor. Let's say you are the disabled party, you're the person who suffered an injury or illness, and you're wanting to protect your assets and maintain benefits. You're the grantor of your own trust, and you're your trustee. That is the self-settled special needs trust. In most circumstances, again, we do third party special needs trusts. Parents are the grantors or grandparents. Whoever's putting their money into that fund, granting their money, that's the grantor. They'll typically also be the initial trustee, managing that portfolio and ensuring that the inheritance is protected and grows properly for the ultimate special needs beneficiary of that trust. The beneficiary cannot be the trustee. So we would name someone other than the beneficiary to manage that fund on behalf of the beneficiary to ensure that they keep benefits and to ensure that the portfolio is properly managed under the prudent investor rule.
So in that case, who do you have an example of, like, who would be a good somebody? Let me go back because I have so many questions. So who should serve as the trustee? Like, what would be the best practice?
Yeah, you really have to trust the trustee, and that's, the root of the word. You have to trust that person to manage the portfolio, to have the tax filings done, and to make sure that the beneficiary is taken care of, not just financially, but medically. I mean, this is where special needs planning is really important
Hmm.
because you want to make sure that whoever you list as trustee after you're gone is going to prioritize your beneficiary, not just the financial health, but physical and mental health of the beneficiary, and ensure that they have proper living and a good experience in life. When we set up our special needs trust, we have pretty rigid guidelines that are clearly spelled out that the priority is the health of the beneficiary and the well-being mentally and physically. So the trustee is going to have broad authority to spend money for the benefit solely of the trustee, medically speaking and for quality of life purposes. So I would list either somebody that you trust literally with your life or your child's life, because that's ultimately what this is it's controlling for the quality of the special needs beneficiary's life during their lifetime.
Yeah.
Or if there isn't somebody who you trust to that extent, there are special needs trust companies out there. Our firm will serve as trustee. There are
Perfect.
plenty of trust companies that will serve that specialize if you don't have that person within your network or your family.
Yeah. And I was going to ask that question if a law firm can serve as a trustee.
Yeah.
Now, how often should a family review the trust?
Yeah, yearly is what we do. So every summer we send out annual review newsletters, basically.
Okay.
So an annual review is important. If anything's changed with the assets or the family dynamic,
Hmm.
typically, within the year, it's good to catch that
Yeah.
and to make sure nothing's changed. There's been a death in the family or a worsening in a medical condition or new benefits issued for a beneficiary. Those are all important times to have documents reviewed and to ensure the strategy still makes sense.
Yeah. Now, so we talked about and should serve over all the reviews. And again, I apologize, but I had all these questions because I believe it's important. So one of the things that also families, I believe, should understand is that a special needs trust or revocable trust or whatever trust they applies to them, that's one component of other documents that would complement that trust. There's power of attorneys, there's
Mhm.
guardianships, there's a lot of other. So I think it's important not to say that special needs trust is a major, factor within the planning process, but it's a component of a much bigger picture. Do you agree?
Oh, absolutely. Yeah, the trust is important for the assets, but it's important to have powers of attorney in place, medical and financial powers of attorney, not just for your child. Once they grow up at age 18, they should have their powers of attorney executed so that there's no guardianship proceeding that's required. But for you as parents or grandparents, it's important to have your own powers of attorney set up because if something happens to you, and the trust has not yet been funded, or if you've moved and you haven't accounted for that and added that new property to the trust, or
Mm,
if circumstances have changed and
yeah.
the beneficiaries, some of them have passed away or are no longer part of the picture, the powers of attorney allow for the updating of all of these documents. And you don't want to have to worry about a guardianship proceeding. They're like a probate, they're expensive and they take a long time.
A lot. So, in regards to the distributions, I think it's also something that we can talk about because something is to set the trust, we fund it, we have a trustee assigned, we have everybody assigned, but now it's also good for a family to understand that they can put their own instruction, the wishes and everything else will be instructed within the trust, right? So I think it's also good for families to understand that.
Yeah, absolutely. The instructions are in there not just for the finances, but as to how medical care is carried out, the guidelines for a care manager. You can even put in there which facilities or which home health aides you would want to assist
Mm,
your child or children or any special needs beneficiary. You can layer in guidelines for what sort of activities you would want your child to or any beneficiary to enjoy and direct the trustee to continue the same sort of habits. I mean, we were just talking before this, maintaining the habits of the special needs beneficiary and their quality of life are pretty much one and the same. I mean, it's going to be difficult for anybody when you've passed away, especially if somebody who's really depending on you for the entirety of their lifetime, basically, or a lot of it.
mm-hmm.
So you can fully customize that and make sure that their quality of life continues on as it was prior to your passing.
Yeah, and have you seen any like challenges? Are there any common challenges when setting up a trust that families, should some way avoid them?
Yeah, that's a really good point. A couple of challenges is, there's a few. Number one's blended families. I mean,
Mm,
if you have kids from prior marriages, say one spouse has a special needs beneficiary, the other spouse does not, and their child's from a prior marriage, we
yeah.
might be looking at two completely different trust structures here.
Mm,
Not
yeah.
uncommon to have a
Yeah.
trust for husband, trust for wife, or vice versa, with or without special needs provisions. So separate planning might be necessary if there's a blended family, meaning kids from prior marriages or relationships. Also, if there's any international component, if there are
Yeah.
assets that are abroad, that is
Yeah.
a whole nother, conversation. But
Yeah.
basically, when we structure our trusts, they're domestic. So they're to hold American assets. If we structure a Florida trust, which is where I'm licensed, you can hold assets in all 50 states in that trust. But if you have assets in Canada, Mexico, or some other country across the pond, the problem is you're looking at setting up a trust in that jurisdiction. So
Yeah.
those are two concerns that I come into contact with: family dynamic and asset structure.
Yeah. And talking about family dynamic, there's the blended side, but then there's the sibling that possibly could become a future guardian or caregiver. That also is it's a topic by itself, right? Because if that sibling, even though they could agree to become a guardian or they're on board, things change in life, right? They evolve, they have their own children. Sometimes even though they committed at one point, life goes on and they want to do their own life, right?
Right.
So I've seen that. I've seen that. So it makes sense. Now, what would you say if a family wants to contact you and they want to start? What would you say would be the first step aside from just the discovery, but what would they need to prepare for that call?
Yeah, it's pretty easy for me. For the first call, it's us getting to know each other and me answering your questions. I never charge for initial consultations. You'll have access to my cell, my personal email. But basically, we'll get to know each other on that first call. And then what I do is I have an intake form that I will fill out alongside you, or if you want to take your time filling it out, I can scan it over to you. But basically, what I'll need to know is real estate ownership, because, like we talked about, titling is just as important as the trust itself. The
Mm.
funding process requires me to have knowledge of corporate and real estate assets that you own, who you bank with, so
Yeah.
where your checking and savings accounts are located, who you have for brokerage accounts, if you have Schwab or Fidelity, and the nature of those accounts. I don't need socials, I don't need account routing numbers, nothing that personal, but I do need to know who you bank with, and what types of accounts you would own, in addition to the real estate and corporate assets, life insurance, and annuities as well.
Okay. Okay, perfect. Now, can you share your website, your contact
Yeah.
information, anything else?
Yeah, absolutely. So, we should have that at the bottom or somewhere on the screen. But Smith Will and Trust, that's SmithWillandTrust.com, smithwillandtrust.com. We just do estate planning, hence the name Wills and Trusts. We don't sue anybody, so we don't have any billboards where, we're talking about winning a lot of suits, because we do transactional work. Transactional meaning we win every time because we're helping families.
Mm.
We're setting up trust funds that prevent loss of benefits, that avoid probate. I mean, the statutory fee for a probate is 3% of the assets going through it. So if your kids not only have to lose benefits, but write a $30,000 check for $1 million property or financial accounts that go through the probate process, it's saving the cost of creation many, many times over. So, that's my website. My cell 727-424-1464. You can call or text me anytime, and we'll be happy to help walk you through the process.
That's awesome, man. And if you would, if you would give anybody some type of advice, this is a underserved, this is an underserved community. Everybody's in survival mode. It's very hard to be a functioning parent while being exhausted. And
Yes.
and it's even more, I would say it's even more difficult being exhausted and trying to look for resources.
Yeah.
Right. So what would be your final thoughts for those families who are survival mode, but at the same time, they need to plan?
Sure. Well, I would finish with this is a lot easier than it looks and sounds like,
Mm.
because the reality is we've been doing this a long time. I've personally done thousands of trusts in the state of Florida, and I've seen a lot of these issues. I mean, no attorney has seen everything, right? But I've seen a lot. And I will tell you that it's a lot easier to do this on the front end than
Yeah.
it is to do it on the back end. So a simple 30-minute conversation will give us enough information to get a draft over to you to take a look at,
Mm.
to see if there's any questions or adjustments to the documents that we're proposing, and then another 30-minute call to go over questions and concerns. I mean, I can't tell you how many times where I've had 2 or 3 meetings with clients, just a couple of hours over the course of a week or two, and we can have that plan put into place. This doesn't take, months or years. We can
Yeah.
do this in a matter of weeks and have a few hours worth of conversations, to really, nail down what's necessary to protect the estate. So I'd finish with it's not as painful as it sounds.
Yeah.
This can be done pretty efficiently and can be done well.
Yeah. No, and I think that everything starts with a conversation, right? So, Christian, thank you so much for your time. It's been awesome. We also need to start planning for possible future webinars for our
Sure.
audience. But thank you so much for your time.
Of course. It was a pleasure. Thanks for having me.
Thank you. And everybody, I will put all Christian's links below. So you can visit his website, you can contact him, you can book a call. Okay. Thank
Thank
you.